Welcome to this explainer. We're going to dive right in today and act as your Socratic seminar guide, breaking down the highly complex and honestly, constantly evolving world of covenants not to compete. We'll be tackling this by digging into some foundational case briefs, examining that classic tension between majority and minority legal views, and getting you totally up to speed with the absolute latest federal updates.
Here is our roadmap for this session. We're going to start with the FTC rule update, move on to our foundational case, Lumley v. Wagner, break down the reasonableness test, explore the severability split, and then finish up by testing your knowledge with the student Q&A.
All right, Section 1, the FTC rule update. Talk about regulatory whiplash, right? In May of 2024, the Federal Trade Commission dropped a final rule that attempted a near-total ban on almost all employment-related non-compete covenants. But, boom, immediately all throughout 2024 and 2025, that rule was hammered with massive litigation and preliminary injunctions. And ultimately, due to all those legal challenges and administrative shifts, the rule was officially withdrawn in 2025.
So, what does this actually mean for us today? Well, the major takeaway is that there's absolutely no federal ban. Instead, we're left navigating this massive state-by-state patchwork. You've got states like California and Minnesota that ban them entirely in the employment context. Then you have others, like Colorado and Illinois, enforcing partial bans based on things like salary thresholds or specific industries. Another absolutely crucial point to remember here, there is no such thing as an implied non-compete. It has to be expressly written into a contract. Because of all this strict and fragmented regulation, we're seeing businesses heavily pivot to non-disclosure agreements, or NDAs, as a safer alternative to protect their customer lists and trade secrets without technically restraining trade.
Moving right along to Section 2, our foundation, Lumley v. Wagner, from 1852. To really grasp modern employment restrictions, we have to travel all the way back to an English High Court of Chancery case. And honestly, the facts here read like a 19th century soap opera. Johanna Wagner, a highly famous opera singer, signed a contract to sing exclusively at Her Majesty's Theatre in London for 3 months. She explicitly promised not to sing anywhere else. But she breached that agreement because the rival Covent Garden Theatre offered her a bigger paycheck. The legal issue this created was fascinating. The court knew it couldn't force her to sing. That would literally be involuntary servitude. But could a court of equity grant an injunction to just stop her from singing for the competitor?
And here is the game changer of a legal principle established by the Lord Chancellor. He basically said, look, courts absolutely cannot enforce specific performance, meaning we can't legally drag you to a stage and force you to perform. However, they can enforce an express negative stipulation, meaning they can issue an injunction to stop you from working for a direct competitor during the term of your contract. It binds the conscience of the parties and stops them from financially benefiting by breaking a totally unique personal services contract.
All right, let's jump into Section 3, the tripartite reasonableness test.
Fast forward to today. For any non-compete clause to actually survive judicial scrutiny, it's got to pass this 3-part test. It looks at the what, the scope of the restricted business activity, the when, the duration of the ban, and the where, the geographic boundary. Think of this test like a giant rubber band. These 3 variables are in a state of structural tension. If an employer wants a really broad geographic scope, they generally have to shrink the duration or narrow down the restricted activity. If they don't, the rubber band snaps, and the court will strike the whole thing down as an unreasonable restraint on trade.
Now, context is everything here. Courts look at these tests way differently depending on the situation. If an employment contract restricts a standard worker, courts are highly skeptical. But if a business is being sold as a going concern, courts are much more forgiving. Why? Because of one huge concept, goodwill. When you buy a functioning business, you are buying its reputation and customer loyalty. The non-compete in a business sale is strictly there to protect that purchased goodwill. It ensures the seller doesn't just take your cash, walk across the street, open a new shop, and immediately steal back all those loyal customers they literally just sold to you.
Makes sense, right?
Which brings us to Section 4, case briefs and the severability split.
So what happens when an employer drafts a non-compete that is just completely unreasonable and ridiculously overbroad? Well, we have a classic showdown here highlighting the majority versus the minority view. On one side, we've got a 1971 New York case, Karpinski v. Ingrasci. An oral surgeon restricted his employee from practicing any dentistry, general or oral surgery, across 5 rural counties forever. Yes, literally forever. On the other side, we have a 1977 Georgia case, Schultz v. Broniak.
Here, an auditing firm restricted an employee from working in any capacity for a competitor across a massive 6-state territory. Both of these contracts are severely flawed. So how did the courts react?
These two cases perfectly capture a huge jurisdictional split. New York applies the blue pencil approach. The court essentially acts like a strict editor. If a piece of the contract is bad, they just cross it out, they sever it, and enforce whatever reasonable parts are left over. Georgia, on the flip side, takes the all-or-nothing approach. Their Supreme Court explicitly refused to rewrite the contract. Their public policy rationale is brilliant. If courts just fix bad contracts, employers will intentionally write terrifyingly broad agreements just to scare employees, knowing a judge will bail them out later. So in Georgia, if one part is overbroad, the entire thing goes straight in the trash.
Let's zoom in on that Karpinski decision from New York. Applying our tripartite test, the where, 5 counties, actually matched the surgeon's referral area perfectly, so that was okay. The when, forever, was surprisingly upheld too, because professional medical practices have lifelong goodwill in their communities. But the what was totally flawed. Banning the employee from general dentistry was way too broad, since the employer only practiced oral surgery. So using that blue pencil rule, the New York court literally struck the words general dentistry right out of the contract and enforced the injunction solely against oral surgery.
Now compare that to the Schultz decision out of Georgia. This employer completely failed the tripartite test. The geographical restriction covered 6 whole states without any real justification, and the scope barred the employee from working in any capacity whatsoever. I mean, under that wording, he couldn't even work as a janitor for a competitor. The employer actually begged the court to blue pencil the document to save it. The court gave them a hard no. They struck down the entire restrictive covenant as an unjustified, void restraint on trade.
Okay, let's wrap things up with Section 5, Testing the Law, with a student Q&A.
We've covered the rules, the case law, and the jurisdictional splits. Now it's your turn in the hot seat to apply this from a student's perspective. Imagine this hypothetical. Abel sells his neighborhood grocery store as a going concern to a new buyer. To protect the store's goodwill, the buyer wants Abel to sign a non-compete. Which of these 3 variations of a non-compete clause would a court actually enforce? Let's test the what, when, and where.
Ready for the twist? Every single one of these fails the tripartite test. Let's break down exactly why. Variation 1 restricts Abel from any business activity. That totally fails the what test. It's way too broad. He sold a grocery store. You can't stop him from opening up a mechanic's garage. Variation 2 says he can never operate a grocery store again. That fails the when test. An eternal ban outlives the purchased goodwill of a local shop. Eventually, the new owner's going to build their own reputation. And Variation 3 restricts him within a 100-mile radius. That fails the where test. The geographic draw of a small neighborhood store simply doesn't extend 100 miles, making it completely unreasonable.
As we wrap up this explainer, I want to leave you with a real thinker. With the federal landscape actively shifting and state laws fragmenting like crazy, how on earth should public policy balance these competing forces? On one hand, you've got an employer's legitimate right to protect their hard-earned goodwill, trade secrets, and investments. But on the other hand, an individual has a fundamental basic right to earn a livelihood and use their skills in the open market. The immense tension between those two realities is exactly why covenants not to compete remain one of the most hotly litigated areas in contract law today. Thank you so much for joining me for this deep dive, and keep questioning the frameworks around you.